Welcome once again to Lehto's Law. Here's Steve Lehto.
I've shot several thousand videos for YouTube, and it's gotten to the point now where I can't remember when I talked about something in particular. I'll remember that I talked about it, I just don't know which video it was in. But every now and then I'll do a video which will be on the internet for months and then years, and it'll still get me comments from time to time on the exact same thing. And so it's often an offhand comment I make where I'll just say something, and then people, for whatever reason, will watch the video and react to that one thing. And it usually isn't even the main part of the video. So in a video a while back, and I forgot, and I apologize, I don't know which one it is, I mentioned going to court, and I said, you go into court, you swear to tell the truth, whole truth, nothing but the truth, so help you God, and you put your hand in the Bible, and then you get up and you testify. And I was simply talking about the cliche image of someone doing this in court. And you know what this means, right? That's your right hand up to testify, and that's your left hand on the Bible. And I was simply pointing out that if you've watched TV, okay, and you've seen someone being sworn in, 99 times out of 100, it's this, and their hand is on a Bible. And you've seen that before. So I was merely pointing that out as the meme, right? That's just what it looks like. But I've gotten so many angry emails from people going, Steve, I would not swear on a Bible. I can't believe you do that, blah, blah. I don't make up the rules for how anything works, especially not in the old days. And I wasn't saying that if you are called to testify in court, you're going to be swearing on a Bible, because you won't be if you don't want to be. You don't have to. But I hadn't addressed that particular topic. So I decided I was going to do a video specifically on the requirements for testifying in court. Because the real question is, do you have to put your hand in a Bible? What if you don't want to put your hand in a Bible? What if your religion actually says you should not take an oath? What if you find raising your right hand to be offensive to your religious sensibilities? And these are all legitimate concerns. Now, 150 years ago, that might have caused you trouble, but not today. Not today. So I went and poked around and I found the case in Michigan that explains this. And I suspect that most other states in America are very similar to this in the modern courtroom. The modern courtroom will not require you to use a Bible. It will probably not require you to put your hand on anything. And it probably will not require you to raise your hand if you object. But I'll explain it in a way that I can show you how the court reasons this through. So the best case on this in Michigan is from the year 2007. It's an appellate case. And the case is called Donkers versus Kovach, okay? And so Donkers is the name of someone who refused to raise their hand to be sworn in court. So this is a case where Donkers and another plaintiff are appealing the dismissal of their lawsuit. The plaintiffs sued their former attorney for alleged legal malpractice. During the course of discovery in that case, the defendant sought to depose Plaintiff Donkers. At the time of the deposition, she refused to raise her hand and be sworn under oath. She claimed that raising her right hand would violate her religious beliefs. At a subsequent motion hearing before the trial court, Donkers again refused to raise her right hand and to be sworn under oath. And what's going to drive you crazy the way it drove me crazy is they have the entire dialogue here between her and the judge. And she was trying to explain herself, and the judge kept cutting her off and finally shut her down in such a rude manner that I think the judge should have gotten in trouble. And I'll let you know that the Court of Appeals, by quoting this entire section of the transcript, is trying to make a point about how badly this judge behaved. Donkers refused to raise her right hand and be sworn under oath in court. She indicated that she would affirm to tell the truth, but stated she was unwilling still to raise her right hand for religious reasons. When she refused to raise her hand as part of her affirmation to testify truthfully, the trial court dismissed her case, threw her case out. In addition to legal malpractice, plaintiff's complaint set forth several other claims, but those aren't important here. But we have to let you know that Michigan's Constitution says no person shall be rendered incompetent to be a witness on account of his opinions on matters of religious belief. Then our law says no person may be deemed incompetent as a witness in any court, matter, or proceeding on account of his opinions on the subject of religion. No witness may be questioned in relation to his opinions on religion, either before or after he is sworn. So that's from the Michigan compiled laws. the blue books behind me. So what happened in court was the court asked her to swear in so that the court could ask her questions about what happened at the deposition. Court says, are you going to raise your right hand or not? Donker says, no, ma'am, it's written. And before she can finish that word, the court cuts her off and says, okay, if not, then I dismiss your case. You may take it up on appeal. Donkers goes, ma'am. And the court says, your case is dismissed. So then the defense says, thank you, Your Honor. Plaintiff says, ma'am, I haven't been given an opportunity. The same thing happened at the deposition. The court said, that's right, your case is dismissed. Donker says, I didn't have an opportunity to state what my substitute oath would be. And the court just turns to the defendant and goes, if you'll submit an order. And the defendant says, Your Honor, could I have 7 days to submit the order? Because the court rules say you get 7 days. And the court says, you may. Kovac says, thank you very much. That's the defendant. Donker says, ma'am, I'm going to object. I haven't been given an opportunity to say what my and the court cuts her off again. You know what you do when you object? You appeal. You appeal the Court of Appeals and explain to them why it is that you will not affirm that you'll tell the truth on a deposition. There is nothing religious about that. There is no basis for any religious objection. The case is dismissed. And again, the judge won't let her talk. So she says, I had offered to tell the truth. This is exactly what I offered to say at the deposition as a substitute for an oath. And then she points out she's testified before with no problems. I've had no problem at any other court in Michigan. I've had no problem in Nevada. And the court says the record is turned off. So you're talking to the wind here. First of all, the record was not turned off. You know how we know? We're reading about it in an opinion. But number two, I have seen judges try to shut attorneys down who've stopped talking long before this woman did. And I got to give her a ton of credit for that because she kept trying to make a record so she could show the Court of Appeals what was happening. So the Court of Appeals takes this case up and says, by the way, this woman's completely right. The judge is completely wrong. Plaintiffs argue the trial court made a mistake in concluding that Donkers was required to raise her right hand in order to affirm that she would testify truthfully at her deposition and in open court. Therefore, plaintiffs assert that the trial court abused its discretion by dismissing their case. We agree with plaintiffs and conclude that the act of raising one's right hand is not required when affirming to testify truthfully. And so the court starts laying out some of these standards, and it says that dismissal of a lawsuit is the harshest sanction that a court may impose on a plaintiff. As a result, a trial judge must follow the procedures set forth in the court rules before doing so. We acknowledge that the trial court is authorized to consider dismissing an action as a sanction when a party refuses to testify. However, Donkers did not refuse to testify. She merely refused to raise her right hand. Chapter 14 of the Revised Judicature Act, which is in the blue books behind me at MCL 600 at SEC, mandates that witnesses in judicial proceedings swear or affirm that their testimony will be true. And that's important. I once had a client before a deposition tell me, he goes, Steve, my religion forbids me from taking an oath. And I said, okay, if asked to affirm that your testimony will be true, can you say yes to that? And he said, yeah, of course. I just can't swear an oath, but I can affirm to tell the truth. So I told the court reporter that, who was at that time going to be, doing the oath, and I said, my client cannot swear an oath, but he will affirm to tell the truth. And the court reporter had a list of acceptable oaths, and one of them says that you will affirm your testimony. So I know we're splitting hairs here, but this is a very, very serious topic for people who have these beliefs. So you must affirm that your testimony will be true. And so that section, MCL 600.1432 sub 1, provides for the manner of administering oaths. The usual mode of administering oaths now practiced in the state by the person who swears holding up the right hand shall be observed in all cases in which an oath may be administered by law, except as otherwise provided by law. Except as otherwise provided by law. Among the exceptions to this rule, it says that every person conscientiously opposed to taking an oath may, instead of swearing, solemnly and sincerely affirm under the pains and penalties of perjury. And what they're trying to get across here is, number one, they want people to understand that what you're doing is very serious. When you're being asked to testify in court, it's serious. Take it seriously, okay? Number two, understand that if you get caught lying on the witness stand, there will be consequences. So this kind of helps put that thought into your head about how serious this is. So this is very serious. So you must solemnly and sincerely affirm under the pains and penalties of perjury that you'll tell the truth. It is therefore otherwise provided by law that in lieu of swearing an oath, a person may solemnly and sincerely affirm to testify truthfully. What is less clear is whether a witness who elects to affirm to testify truthfully must also raise his or her right hand. Well, I can stop this right now and tell you what happens if somebody has no right hand. Person's got no right hand. Oh, I don't know, they could raise their right arm. What if they've got no right arm? I mean, and you ask yourself and go, wait a second, what's the right hand got to do with it? And obviously, it's something old that goes back so long that we don't know where it started. I mean, someone's going to chime in and go, Steve, they found out in the Code of Hammurabi or something. The point is, we don't know. And does it really matter? What if your arm was broken? What if you literally had your arm in a cast, a cast that went up to here like this? Are you still going to and raise it? Like, seriously. So obviously the raising of the right hand is the least important part of this. So our primary task in construing a statute is to discern and give effect to the intent of the legislature. To do so, we begin with the language of the statute, ascertaining the intent that may reasonably be inferred from its language. The words contained in the statute provide us with the most reliable evidence of the legislature's intent. So the court points out that these two different sections relate to the same subject matter and share a common purpose. Accordingly, they must be read together as one law. When two statutes are read that way but conflict with one another on a particular issue, the more specific statute controls over the more general. Accordingly, one of them provides a specific exception to the general rule of the other. So, although one provides a specific exception to the general rule, it does not provide for the manner of administering affirmations. Of central importance in this case, it does not address whether the upraised right hand, apparently necessary to effectuate an oath under one, is required when making an affirmation under the other. The omission of a provision in one statute that is included in another should be construed as intentional, and provisions not included by the legislature may not be included by the courts. Indeed, courts cannot assume that the legislature inadvertently omitted from one statute the language that it placed in another, and then on the basis of that assumption, apply what is not there. So that's talking about whether or not you have to raise your right hand, and obviously you do not. So it says, because Donkers chose to affirm to tell the truth, rather than to swear an oath, she was not required to raise her right hand when doing so. So she was not required to do that. So our conclusion in this regard is further supported, and they point out that there's actually Michigan rules of evidence that talk about when someone testifies, now their testimony is handled, and it addresses a person being sworn in. Likewise, the federal rules are almost identical. In fact, in Michigan, they might be. Our rules, MRE 603, the federal rules are FRE 603. And so what's interesting about this is that it doesn't matter with the exact form of the oath. What matters is that the person said in open court that they promised or affirmed to tell the truth. And this court actually found other examples where it had been upheld that someone's testimony was good, because someone gets convicted, they start going through the record for every single thing they can find to complain about, and they go, oh, this one witness wasn't sworn in properly, therefore their testimony's no good. And in that case, the trial court asked one of the witnesses, can I get a promise that you will testify truthfully, please? And the court stated to another witness, I need you to promise that the testimony you're going to give will be accurate and truthful. Do you promise? So that's really the gist of it, is that when you come into court, you've been called as a witness, and at the risk of causing another whole rabbit hole situation here, call the next witness. Your Honor, we call John Smith. And the bailiff opens the door into the hallway and goes, John Smith. And someone walks in. They walk up to the front, and somebody, often a bailiff, could be a court reporter, might even be the judge, asks them to take an oath. And no matter what they say to the witness, at least in Michigan, can say, my religion forbids me from swearing an oath. Is it okay if we do something else? And the court should say, yes. Will you promise to testify truthfully? Yes. Have a seat and start testifying. That's really the point of it. And so I know a lot of people who think that lawyers live and die by nitpicking rules, and that nitpicking rules, therefore, somehow are the engines of the court. And sometimes they can be, but not always. And so sometimes you can look at something and go, what are they trying to get at here? And so you'll notice they never mention a Bible in any of this, by the way. So the old school thing about that has gone by the wayside. And again, I'm sorry if people took my earlier comments in the previous video to mean that regardless of what happens, you will be forced to put your hand in a Bible. No. So if you get called to testify, depends on who's going to call you. You will usually know. Very few people get hauled in from the hallway without knowing they're going to testify. And so when someone says, are you willing to testify? And you say, yes, I am. If you have a concern about this, you tell that person, because they're the ones with a vested interest in having you testify appropriately. And so the last thing that I would want as an attorney, if I call a witness, is to have the witness start off their experience in court with an ugly exchange where an old school judge whips out a Bible and says, here, swear to tell the truth. And now the person's looking at it going, okay, I got to tell a judge, put that Bible away, and I'm not going to raise my right hand because I don't take oaths that way. I'll only affirm to tell the truth. And so I, as an attorney, would let the court know that. And how I let them know that depends on the court and how informal or formal the things are. But I can tell you, at least in the one example I remembered from years ago, I had a client before his deposition tell me and said, I cannot swear an oath. It's contrary to my religious beliefs. And I said, okay, can you affirm to tell the truth? And he said, yes. I said, okay, we'll take care of that. Now, that's a deposition, but you can imagine you can do the exact same thing with a court. But trust me, if you say, I cannot put my hand on a Bible and swear an oath because it's contrary to my religious beliefs, you will not be told that you have to do that. So again, trying to clarify that, but the case, in case you're curious, is called Donkers, D-O-N-K-E-R-S, Donkers versus Kovach, K-O-V-A-C-H. Google that, you will find it very quickly. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Common sense is so rare, it's now considered a superpower.